I'm now being joined on the program by one of the lawyers who actually appeared in this case to give his own opinion at the Supreme Court, Professor Ishe Sagie. Professor Sagie, thank you very much. He's joining us actually on the line here in Lagos. Professor Sagie, thank you very much for joining us. Let me ask you this. There's a lot of confusion this case is generating, and that's in reference to Kogi and Bayelsa. What exactly should be the position?
Okay, first let me clear one thing. The Anambra case has nothing to do with this case. This case, in the case of Anambra, the governor was being elected for the first time. In the case of these five governors, it was a case of self-succession. So the same principle cannot be applicable.
Okay.
Yes. Now going to the issue of Kogi and Bayelsa, I think we can find a solution by looking at the judgment itself. The judgment stated that the effect of nullity, of the declaration of nullity of an election, takes place from the date of that pronouncement, and that the effect of it is that of a voidable and not a void election. Now, if it is voidable, it means anything done before the court pronouncement is valid and sustainable. The court also went on to say that those governors whose elections were voided, whose tenure was voided, were de facto governors.
Okay.
That was the word. They are de facto governors. So for all practical purposes, they had authority during that period. Now, if you follow that principle, what it means is that anything that happened before the judgment on Friday 27th under those governors was valid.
Oh, really?
Yes.
So we could as well. Let me ask you specifically, for instance, in Kogi State, there is a confusion. You know, in that state, there is a governor-elect, and the governor-elect was actually sworn in by, was sworn in by the president of the Customary Court of Appeal. But later in the day, on Friday now, the chief judge of that state swore in the speaker of that state as acting governor. What should have been the position now? Are you, in essence, saying the governor-elect should have been sworn in as governor of that state?
That is my view. I think the mistake he made was allowing the president of the Customary Court of Appeal to swear him in. It should have been sworn in by the chief judge of the state. Now,
can that mistake be rectified? Can it be rectified, or he ceases to even be governor-elect?
Well, as I see it now, the matter can only be settled in court, since there are two contending governors. But clearly, if you follow the principles which have been laid down by the court with regard to the effect of nullification of election, and if you also recall that both the High Court and the Court of Appeal had, in fact, validated the tenure elongation, the law that existed at the time Idris was elected, supported the validity of his own election.
Yeah.
So the Supreme Court judgment coming later, since it does not have a retrospective effect, cannot affect his election. So he should have been the one sworn in.
And the same thing would apply in Bayelsa State, for instance?
No, Bayelsa State is different.
No, the reason I'm asking is, there is a contention as to who should be the candidate of the PDP. So from what you're saying, it would appear, it would be right and proper for Dixon, who emerged the governorship candidate in the second primary, to be the candidate of the PDP in that state.
Well, I don't want to be specific and say it's Dixon, but
I know you're just giving your opinion.
Yes, what I want to say clearly is that the January primary, whenever it was done, the one that brought Silva in, has lapsed. Because he himself abandoned it, the PDP abandoned it, the election that was supposed to that primary election have been conducted, and they are all gone. So the next valid nomination or primaries are the ones that were done subsequently. Now, whether Silva can challenge that on other grounds, I do not know. But those are the ones that will, that's the one that will stand.
Well, thank you very much, Professor Sagie, for your opinion there.
Thank you very much.
Yeah.
You're welcome.
Yeah, Professor Ishe Sagie, a senior advocate of Nigeria, talking to us, giving us his own perspective on what is now becoming very confusing. Let me come back to you here in the studio. You heard him, you have Professor Sagie, and you know, it would appear, you know, he was speaking in line with that presumption thing he talked about. So what's your take on that? The situation in Kogi and Bayelsa.
Yes, I align myself with the views of the learned professor. You know, because I was almost going to disagree with him if he said that the Silva's primaries the primaries conducted in January last year, that it was going to stand. Then I was going to disagree with him. But luckily, he said what was in my mind. But let's talk specifically about Kogi.
Okay.
And we are going to apply both law and politics, you know, to be able to understand that. I am surprised that the Attorney General gave such a blanket order that for the 5 states, that the speakers should take over, you know, the governance of those states. Specifically speaking, Kogi State has conducted an election. Indeed, it has even nothing to do with the governor, because it wasn't the governor that conducted the election. It was the party that, you know, conducted the primaries, and it was INEC that conducted the election. Good. So the governor is out of it, whether his tenure had been nullified or not. You know, it's not material in this argument. If there is a substantive governor-elect, because that's what he is, and the Supreme Court had just said that the tenure of the incumbent or the former governor had long lapsed. That is to say that he would have stopped being governor since May 29. Almost invariably, the governor that had been elected, in short, because there are going to be fresh elections in all the other 4 states, but one had been conclusively made. That is, it's been concluded. He simply will be sworn in. I was shocked that the speaker was sworn in, such that we had 2 governors in one day in Kogi State.
And I should say,
in the morning.
One of the reasons, as we were told, one of the reasons why they had to get the president of the Customary Court of Appeal to swear in the governor-elect was just because the chief judge of the state refused to perform the ceremony.
That's part of why I'm telling you that this analysis has gone beyond illegal analysis. You have to have some political undertone. You know, if you look at the political undertone, then you begin to understand it. Namely, who gave the instruction? Adoke. And incidentally, he's from that state, I guess. Where is he aligned to? I mean, because that's how you look at a political decision. What is his interest in the matter? Why wouldn't he exclude Kogi State, where a governor-elect is waiting? In short, waiting for the term of office of the former governor to elapse, I think about the next 2 weeks or 3 weeks and all of that. All of a sudden, that position becomes vacant by the pronouncement of the Supreme Court. He simply will be sworn in. There is no other overriding argument to that. And I encourage him to go to court tomorrow morning and get the court to declare that he should be sworn in, because the speaker has no business being sworn in Kogi State.
Let me get your view on this, Mr. Gonya.
You know, these are uncharted territory. Mm-hmm. So when lawyers are proffering opinions, we have to do so.
No, of course, these are opinions, and they've made it clear.
No, I'll make my point very clear. Now, on Kogi, first on the judgment. I've read part of the judgment. And I can report that contrary to what many people believed, there is a portion of the judgment, support judgment, by Olufunlola Adekeye, to the effect that the speakers of the states should be sworn in as acting governors, pending the time fresh elections will be conducted. Therefore, in my view, the Attorney General of the Federation acted very swiftly, because it was a situation of looming anarchy. to generate that advice and then urge the chief judges of the state to swear in the speakers. Now, in Kogi State, we are aware, and you said this, that the chief judge refused to swear in the governor. And so the governor and the former governor did the unthinkable by getting the president of the customary court of appeal to come and swear them. And I was reacting to this the other time. I said, yes, the other time there was an NJC meeting and the president of customary court of appeal presided over a meeting where the president of the court of appeal was sacked, okay, or recommended that he be removed from office. And so what are you going to get in this kind of... But that's an aside. But the point is that even in Kogi State, the situation is not as clear as we may think. Now, before these judicial interventions, first at the High Court, Adamu Bello, J, at the Court of Appeal, and now the Supreme Court, certain steps had been taken. INEC had issued notices of election. Candidates had emerged.
That's the first primary.
First primary. Now, that process was truncated by this judicial intervention.
Okay.
And now, the Supreme Court has now eventually ruled that that ought not to have been. So, in Kogi State specifically, a candidate emerged that is different from this.
That was back in January.
Yes.
Yeah, and that brings me to the question you preempted me the other time.
Yes.
If you could presume that everything that happened in office, and that's one of the points too, Professor Sagio raised as well, that if you presume that everything these governors did after May 29th is still valid and all of that, so why can't you allow the second primaries to go ahead?
No. That's not an act of the governor. The primary was not...
Apart from being the act of the governor, every action that took place during the period while he was in office.
No. We must distinguish between the act of state, act of a governor, and act of a political party, and the right of a candidate that crystallized. Now, a candidate had emerged, and now that intervention, judicial intervention, truncated that process.
So for you do not agree with Professor Sagi, for instance, when he said this law, the judgment of the Supreme Court cannot be, retrospective, and that it comes into force the day the Supreme Court
for two reasons. First, I'll say that there is a portion of the judgment that's directed specifically that the Speaker should take over, and a supporting judgment. The Supreme Court has said, edifies and strengthens the leading judgment, and it is wrong for anybody to assume that it's not part of the judgment. Now, second, I've also told you that in Kogi State there are things that happened,
of course.
And so therefore, in the seeming confusion that followed that judgment, it was possible for an Attorney General who was issuing a general directive or advice to so do without singling out or directing that Kogi State be left out.
He just was carrying out a general order. Okay, I'm going to come. Emeka, let me get your take on this. I mean, what is happening in Kogi State at the moment? Because it appears we have two governors. Actually.
Yes, I actually have a different view from this. I sympathize with the governor-elect who was sworn in by the president of the Customary Court of Appeal. Now, I don't think the president of the Customary Court of Appeal does not have the power to swear him in. I checked and I discovered that any of the chief judge, the president of the Customary Court of Appeal, or the grand Qadi of the Sharia Court of Appeal can swear in a governor. So it was just more politics that was played out there. Not because it was constitutionally wrong for the president of the Customary Court of Appeal to do that. Now, but I am looking at it from the point of view of the effectiveness of the Supreme Court judgment. If we agree as lawyers that the Supreme Court judgment took effect from the day the judgment forthwith, as lawyers used to say, I began to look at the Kogi election, and I began to wonder whether that election that was conducted based on the old view, based on the old Court of Appeal judgment that thought the tenure of those governors continued and will end sometime in future, whether that election is valid. We are thinking, because I noticed that the Constitution is actually silent on so many things more than we think. For example, I'm sorry.
Go on.
We've always assumed that Speaker should take over. I saw Kano Agabi SN questioning that.
Yes.
And I began to think, which part of the Constitution says, apart from what my colleague said, that actually a supporting judgment said that? Because I was beginning to wonder, because there is this blanket application of where the Speaker takes over on the Constitution, which are on two occasions. One, when the government has been removed by impeachment, and two, when the government has been medically unfit, incapacitated, then there is no deputy governor, then the Speaker. Outside that, the Constitution is silent. Even the one when they are not at election, the Speaker takes over. I think it's a carryover. It's an assumption that because we have this part of the Constitution saying that, so this must be. So now,
Mr. Agabi could somehow be right when he said, those governors should have been allowed to continue.
Yes, but if the Supreme Court ordered that the Speaker should be sworn in, then, rightly or wrongly, the Supreme Court has to be obeyed. Now, I'm looking at a situation where if this election won by Captain Idris, I really sympathize with the situation. I'm not taking sides. But if the Supreme Court judgment has said election should be conducted in 90 days, I don't think he said excluding Kogi
State.
And if he didn't say excluding Kogi, very soon after tomorrow, INEC is going to come out with what is called notice of election. And if you go to the Electoral Act, when there is notice of election, then you are going to have this notice saying this is when the election will take place. This is where primary, that is, nomination will be submitted under Section 30 of the Electoral Act. That takes me to Bayelsa, where I beg to disagree with Professor Isesage SN, whom when I was a little boy, I used his book.
Okay.
But you see, in Bayelsa, if INEC tomorrow says notice of election, INEC will say in that notice the date of the election. INEC is required by law to say in that notice where nomination will be submitted. And I don't believe now that I was on this program some time ago, based on a different set of facts. I said the latter primary, I gave reasons why that should be valid. Now, I don't believe any of the primaries is valid. I believe there will be a fresh primary, PDP primary in Bayelsa, because immediately the Supreme Court gave that judgment, everything starts. And when INEC issued notice of election now, like I said, the electoral process is a process. It starts from notice, it continues with nomination. From nomination, then you submit Form CF001. And I don't believe it's the Form CF001 and then the nomination form that was submitted before that will apply. So in Bayelsa, we are faced with the situation, but all we are saying, like we said, is opinion subject to what the oracles themselves will say.
Oh, all right. I mean, we're coming to Bayelsa, but I also want you to take a listen to what Mr. Koinsola Ajayi had to say about the situation in Bayelsa, because we put that question to him. Let us take a listen to what he said. When we hear that, I'm going to come back to you.
That's a tricky question, and frankly, I do not. I don't belong to the party, and the parties have their rules. The Electoral Act is clear that it is the party that will determine who its candidates are. So the truth of the matter is this: Silva went through primaries last year and was the nominee of the party. The party, along with Silva, then went to court to challenge the holding of elections to his office. He therefore was suggesting that everything that was done was not properly done, and he took part in fresh nominations. As you all know, he went to the party, he's protested, and he's been challenging the fresh primaries. So I think, honestly, that Silva will be hard put to say that it is the last primaries, the primaries that was held last year, that is valid, and not the one that was, the first one that was held, and not the second one, because he took part in the second primaries. So a man cannot allow to eat his cake and have it. You cannot reprobate and approbate. He can't blow hot and cold. And I think Estopel doesn't really catch him. But if it was a question of Estopel, he'll be stopped because he's giving the impression to everybody, even Dixon and his party, that is going to be part. He'll take part in the primaries. But it's because the party shut him out that he's now latching on to the past. And we can't allow people to do that. Otherwise, our democracy will not move forward.
GT, let me get your, because from what he said, it would appear, the senior advocate of Nigeria there was saying, well, the second primary should be the valid primaries.
I've thought about this matter, and really,
and very deeply.
I hope so. From what I'm going to say, and I want my colleagues here to look at it from these two perspectives.
Yeah, and because somehow what applies in Bayelsa should also apply in Kogi.
Yeah. The first line of argument could be that with the Supreme Court's judgment, life has been breathed back into those processes towards the holding of those various elections, which was stymied with the intervention of the courts.
The two courts.
And since candidates of the party, not just nominees, candidates of the party had emerged in that election, save situation in which any of the candidates of the parties that had been cleared died and therefore would need obviously to be replaced, those candidates would then be the candidates that should stand for this next election. So the question of then issuing fresh notices of election, as suggested by my learned friend, will not arise. That's one way to look at it.
How do you reconcile that with the order that election should be conducted within 90 days? Anyway, just go on.
That's one way to look at that. The second way to look at that is to say, no, that can be. There has been this exclusion of time. A lot has happened, and we can't bury our heads in the sand like ostrich. So what needs to be done is that now with the Supreme Court's judgment, let's have fresh notices. Let there be fresh nominations, and then we will have elections within 90 days, and winners of those elections will emerge. Now, these are the two poles that I see. However, there's a third leg which has to do with the situation in Kogi State now, where a candidate, a governor-elect, has emerged based on an election that was duly and lawfully conducted by INEC, right? Now, the argument that has arisen, even in respect of that third leg, with the emergence of the governor-elect, is that election was based on the assumption that there was an extended tenure, which will, expire in March, sometimes in March.
Assumption.
Yes.
Presumption.
And so the certificate of return that was given and all that was to ensure that he is sworn in March, not in January.
Sworn in.
Okay. Yes, in January. So we have all these, and I know that at least in Kogi State, there's a report that the governor-elect has, prepared to go to court tomorrow. So we'll see how all this will go. But I reckon, and this is my answer.
Very interesting, your views.
And this is my anchor.
You've just given us three options without really picking one.
Yes, and my anchor is that perhaps it will be right for the Attorney General of the Federation to quickly go to the Supreme Court and say, look, you've given this judgment. Give us specific directives. So that, because even if whatever to go to court tomorrow, it's still a gamut. It's a three-layer process, and that may further complicate this matter.
Yes, there is no doubt that some clarification need to be sought, from the court with regard to the plethora of issues that are coming up as confusion. But my view on it is this. I disagree with my learned colleague that the primaries held earlier than now have been nullified by the current judgment.
Is it the first primaries or the second primaries?
Even the second primaries. That is to say that INEC will now call for an election, and the process will start afresh. I've always said, even though the court had said swear in the speakers, of course that's what they should say. But in applying the order of the court, the enforcement of that court has to take cognizance of the fact that there is a governor-elect. And like my colleague said, this governor-elect did not just emerge. He was legally elected, lawfully elected. And to that extent, even if they said swear in the speakers in all the states, for instance, there is in one of those states a valid governor-elect waiting. And the point is this: he was supposed to have been sworn in at the expiration of the office of the incumbent governor. But that particular tenure had been aborted by the Supreme Court order.
So
in other words, that position is now vacant for him to occupy. So he is different from the 4 other states. I mean, Kogi State is different from the 4 other states. Then coming to Bayelsa. The only problem I have, and probably which also is an escape route for Governor Silva, is that as much as the Electoral Act talks about having to get your candidate ready 60 days to the expiration of the office holder, it does not say when you will elect when you will nominate, or at least when you will conduct the primaries to that particular position. So, in other words, if somebody wants to be mischievous, he will say, if that election, the primaries that was validly conducted in January last year, that it could have been that the governor has been waiting as an aspirant, as the candidate of PDP up till now, because there is no time that says you must elect the person 1 month, 2 months, 3 months before. That if you elect anybody, say for instance 6 months to the time, it is invalid. It gives you the time you can elect the person, say 60 days to the election, but does not tell you when you cannot. It tells you when you can, but cannot tell you when you cannot.
Should I just tell you?
So that's an escape route for Silva. But you see, in such situations, the court will construe what time that is reasonable. And what time that is reasonable cannot be January last year for a position now.
Now, honestly, I must tell you one thing. I'm still confused about this whole thing. In spite of your contributions and all of that, but eventually you would agree, because we're running out of time. Eventually, you would all agree that the courts will decide. Will have the final say on all of this.
And the Supreme Court actually said conduct election in the 5 days. That's very serious.
And let me just quickly
serious.
Now that
very quickly.
Look, this confusion will have arisen but for greed of politicians for power.
Sure.
These 5 states that we're talking about, you know that even in Ekiti State, the governor of the state was seeking tenure elongation before it was stopped. In Delta State, was also doing that. So now, when you have a situation whereby incumbents will regret leaving office, even when 8 years, they clock 8 years, just wishing, I wish I had more time. That is the problem we have here. And
indeed, they can instigate somebody to challenge their election so that it will be nullified. And they'll continue from the first state of office. So, in other words, you take an oath of office for about 4 or 5 times. You end up being the governor for 18 years.
For 18 years.
Exactly.
Well, at least one thing is certain, that has been resolved. There's no confusion at all.
And then hopefully, with the amendment, we won't have situations like this.
At least there's no confusion about that, but there's still some kind of confusion as to what should happen in Kogi and Bayelsa State. So we'll be waiting for the courts to...
Last word.
Very quickly.
With this judgment, I think it's important for us to begin to consider law reform amendments, whether the Constitution or the Electoral Act, to reduce the time a governor whose election has been annulled spends before, if he wins, coming back. That's important.
All right.
So that it won't be too long.
All right. Thank you very much, gentlemen, for coming on the program. Chijioke, thank you very much for your time. Gigi Ogunye, thank you very much. Sir George Eke, thank you all for your contributions, even though
it's my pleasure.
The confusion is still there. I still don't know what's going to happen. Well, thank you very much. That's it on the program tonight. Well, the confusion is still on, but I believe in the coming days, things will begin to get much clearer when the courts weigh in. And do not forget, we are expecting INEC to also come up with its own position. We understand INEC will be meeting tomorrow, and probably we'll be hearing from INEC what INEC intends to do in all these 5 states, whether there won't be election in Kogi and who should be the candidate of the PDP in in Bayelsa State. So the confusion is still on until we get a resolution to all of that. As soon as we get that, we'll let you know. So on that note, we say we'll see you next week.